Welcome to our fourth webinar of Data Privacy Week 2025. I am happy to introduce our speaker today, David Lindner. He's the Chief Privacy Officer over at Sidley Austin LLP. David, we'll hand it to you and you can go ahead and get started. As a reminder, everyone, this is being recorded. You'll be able to watch it again after, and we'll look at questions in the Q&A feature. Thanks, David. Take it away.
Yeah, thank you, Cliff. Thank you all for joining today and happy Data Privacy Week. I guess I should give the little disclaimer first off. I'm not a lawyer, so this is definitely not legal advice of any kind. And the views are my own and not of my employer, so we'll get that over with. But what we want to talk about today is, 2024 has been a big year for privacy legislation at the state level here in the United States. So I want to provide a little overview of where we stand, sitting here in January 2025, and really walk through kind of the framework of existing state privacy laws and some notable developments that we had in 2024. So looking at the map, you can see a lot of legislation has popped up, either enacted in 2024, as well as more bills that are, in chamber and committee, et cetera, for 2025. So, 2024, like I said, was a big year for privacy. There was a brief hope that a preemptive federal comprehensive privacy law could come to fruition through the American Privacy Rights Act of 2024, but the patchwork approach to U.S. privacy has continued on at the state level. Currently, the U.S. has about 20 enacted comprehensive state privacy laws, if you include Florida's Digital Bill of Rights, with 7 new comprehensive privacy laws enacted in 2024. And those are in the states of Nebraska, New Hampshire, New Jersey, Minnesota, Maryland, Kentucky, and Rhode Island. So these new state privacy laws all expanded consumer rights, such as access, deletion, portability of personal data, and really also required companies to conduct data protection assessments to address associated risks, such as targeted advertising and profiling, sales of personal data, and processing of sensitive data, of course. We'll cover these advancements a little later in the discussion. But for right now, while variations exist within most of the 20 comprehensive privacy laws, I want to spend some time discussing the framework that these laws are built off in terms of applicability, consumer rights, entity obligations, and exemptions. So let's talk about scope and applicability, because this is, I think, one of the more difficult areas to analyze because there's several part tests for several of these state laws. So first of all, the scope of applicability really varies by state depending on an entity's jurisdiction, revenue, volume of personal data processing, as well as an entity's revenue from the sale of personal data. So starting with jurisdiction, this one's pretty cut and dry. The entity must conduct business in the state in question. So that's the starting point for determining any of these laws' applicability. As it relates to revenue, for strict revenue thresholds, California, Tennessee, and Utah apply if the company has a gross revenues of $25 million or more. And meanwhile, Florida, if the company has gross revenues of $1 billion or more. If this revenue threshold is not met in those states, in Florida, Tennessee, and Utah, then the law will not apply, no matter what personal data processing or revenue from sale of personal data is brought in. California is a little bit different, and you'll hear that a couple times from me today. They have a revenue threshold of, I believe it's 25 million. So if you are a company doing business in California, and your gross revenue is $25 million or more, then the law automatically kicks in and the Consumer Privacy Act in California becomes applicable. So when you get through jurisdiction and revenue, the next question a lot of times you have in most of these state laws is that they have to meet one of 2 thresholds subject to the law. One is in regards, again, to the volume of personal data of the state's residents being processed, and the other is the revenue from the sale of that state resident's personal data. So let's talk about personal data processing first. For the volume of personal data processed, I would say most state privacy laws fall within the 35,000 to 100,000 unique consumers range. However, there are outliers. You have Nebraska and Texas. They have no processing threshold, while Tennessee only applies if 175,000 individuals or more's data is being processed in the state. It's important to remember that these thresholds are also generally exclude personal data that's processed solely for completing a transaction. The second threshold that entities may meet in order for a state's privacy law to apply relates to the sale of personal data. So again here, similar to the data being processed, Nebraska and Texas again have the lowest threshold, as any data process combined with the sale of any personal data would bring the entity within the scope of the law within those two states. The majority of states require entities to process the personal data of 25,000 or more residents and derive between 25 to 30% of their revenue from the sale of personal data to meet their threshold. Again, other outliers such as Indiana, Iowa, Kentucky, Tennessee, Utah, and Virginia, where an entity must process the data of 25,000 or more unique consumers and derive more than 50% of their revenue from the sale of personal data. So as you can see, there's multiple levels here, obviously starting with jurisdiction, going down to revenue, strict gross revenue in certain states, and then also trying to balance and apply whether or not how much information is being processed by the company in that state, as well as the revenue that they may make from the sale of personal data in that state. So I find this to be the more, difficult when you're analyzing. There's so many different thresholds and it varies so much from state to state. But this is a good kind of starting place for you when you're trying to determine what are the, kind of 3 or 4 applicability areas when you're analyzing any state privacy law. So the next thing I want to talk about is consumer rights. So all state privacy laws include a variety of consumer rights around the principles of access, correction, deletion, portability, and opting out. So access, obviously, consumers can request information about themselves and have access to their personal information. Correction, consumers can request any inaccurate or incomplete personal data that a company may have on them. Again, Utah is an outlier here. It does not provide a right to correction. Deletion, consumers can request that their personal information be deleted. Again, Utah is an outlier here. The right to deletion only applies to consumer-provided data. So the consumer has to provide that data in order for it to have the right to be deleted. So the next one's portability. And that's really around providing consumers the right to obtain their data as long as it's maintained in a technically feasible format. This is probably the consumer right that kind of varies the most across state laws. In most states, the right to portability applies to any personal data held by a regulated entity. So that's really banks, credit unions, insurance companies, and other financial institutions. And lastly, opting out. So consumers have the right to opt out of certain processing activities, such as selling their data. That's what you see most often, as well as targeted advertising, and in some cases, automated decision-making. Iowa specifically allows you to opt out of the sale of your personal data, but does not allow you to opt out for targeted advertising or profiling. So again, you see the various differences across these laws as it relates to the consumer rights provided. Next, we talk about sensitive information. So all state privacy laws recognize certain information as sensitive and require additional protections for consumers. The type of information across the board that's generally considered sensitive around all state privacy laws has to do with things like race and ethnicity, religious beliefs, mental and physical health data, sexual orientation, citizenship, any data that may be regarding minors, geolocation information, and of course, biometric data. Some states, like California and New Jersey, also recognize additional data points as sensitive. So in California and New Jersey, financial information is considered sensitive. And in California, they also take it a little bit further. Their sensitive data also includes Social Security numbers, driver's license information, passport numbers, union membership, etc. So there's a lot of additional protections that are provided, as I said, in state privacy laws for this type of information. So most states require entities to obtain consent to collect and process sensitive data and require a risk assessment or a data protection assessment to be performed. California does not require upfront consent. Instead, businesses must provide individuals with the option to limit the use of their sensitive data, as well as notice and the ability, of course, to opt out of sharing or the sale of their personal information. Let's talk about entity obligations. So what do companies and businesses have to do as required by many of these state privacy laws? So they have several obligations. The first being privacy notices. So that they must disclose the company's privacy practices and how consumers' personal data is used. California is the only state that requires notice at the point of collection. Data protection assessments. I'm sure many of you are familiar with these, but for any processing activities that heighten the risk or harm to consumers, a data protection assessment should be performed. Of course, these help identify risk and mitigate any potential concerns, and also demonstrate an entity's compliance with data protection laws. Delaware, Indiana, and Virginia specifically require DPAs for targeted ads, the sale of personal data, and profiling. Iowa and Utah are the only states that do not require DPAs currently, so it's worth noting. Data minimization and purpose limitation. So all states require some level of data minimization and purpose limitation when it comes to processing data. However, some laws are a bit more stringent than others. One recent one is Maryland, which we will talk about in depth in a little bit. But that one states that data controllers must limit their data collection to what is reasonably necessary and proportionate to provide or maintain a product or service requested by the consumer. Additionally, that bill requires the processing and sharing of sensitive data to be reduced to what is strictly necessary in relation to a requested service or product. Next one is universal opt-out mechanisms. Again, we've talked about the various state laws that allow individuals to opt out of the sharing or selling of their personal data. And these opt-out mechanisms are really referring to a wide range of tools that are available, both desktop and mobile devices that can really enable consumers to kind of pre-select their preferences to opt out of certain types of online data processing. So California, Colorado, Texas, Montana, New Hampshire, Nebraska, and Connecticut all have requirements to honor universal opt-out mechanisms. New Jersey will also have requirements starting in 2025, July 2025, followed by Delaware and Oregon in 2026. So something to be aware of within this coming year and next year. And lastly, consent requirements. This one's pretty obvious. Entities must obtain consent in most instances before processing a consumer's sensitive information. Again, California is unique and must give notice about the sale or sharing of their sensitive data upfront and must allow residents with the ability to opt out of such sharing. Now let's talk about the exemptions provided in these state laws. So state privacy laws have built in various exemptions at the entity level as well as the data level. So at the entity level, that means obviously an entire business is kind of outside the scope of the state privacy law and it would not apply. So the majority of new and emerging privacy laws create entity level exceptions for financial services and entities subject to the Gramm-Leach-Bliley Act, as well as the healthcare and medical services related entities that are regulated by HIPAA or the Health Insurance Portability and Accountability Act. Meaning, again, that the whole business as a regulated entity is outside the scope of the state's privacy law. Other laws, however, create exemptions at the data level. So again, if you're talking about consumer financial information that's regulated by the Gramm-Leach-Bliley Act, that information, the data itself will be exempt. However, the business as an enterprise will still be in scope of the privacy law. So what does this mean? It means that although the data, that certain data, financial data or HIPAA related data may be out of scope when it comes to the requirements of the state privacy law, the business itself still has to do public facing disclosures around its data collection practices. and allow, consumers to kind of avail themselves of their statutory rights regarding their personal data and sensitive information that the business maintains. So two different philosophies there that you'll see in different state privacy laws at the entity level and data level when it comes to exemptions. All right, so let's talk about 2024 and some of the significant legislative updates. So as I mentioned previously, 7 new comprehensive privacy laws were enacted in Nebraska, New Hampshire, New Jersey, Minnesota, Maryland, Kentucky, and Rhode Island. And all of those continued the trend of increased consumer rights. So in fact, as I mentioned, the Maryland Online Data Privacy Act of 2024 may be the most consumer-friendly state privacy law passed to date. As I mentioned, Maryland's law creates different data minimization rules based on whether the data at issue is personal or sensitive. Again, for personal data, the controllers must limit their collection to what's reasonably necessary and proportionate to provide the service requested by the consumer. For sensitive data, controllers may not collect, process, or share sensitive data unless it is strictly necessary to provide or maintain a specific product or service requested by the consumer. Maryland's law also prohibits the selling of any sensitive data. In addition, Maryland's law prohibits targeting advertising to individuals under 18. Again, requires regular risk assessments for any processing algorithms that may present a risk to a consumer's privacy. So again, Maryland might be the most, to date, consumer-friendly law in terms of the rights that provides under statute to consumers. But there are other states too that jumped on board. Minnesota was another one that included a few new requirements, including the right to question the result of adverse profiling decisions, and to be informed of actions that could have been taken to secure a different decision. So that one's definitely going into a lot more detail around some of the profiling and automated decision making that may be made, and being able to request the result of that profiling, the impact it had on the individual and what could have been done differently. Rhode Island provides unique privacy notice provisions that require entities to disclose the third parties to whom they may sell personal data to instead of just who they do sell data to. So that one's really interesting. So something to pay attention to. If any of your businesses or companies do business in Rhode Island, that is a very difficult bar to meet when you're determining who you may sell personal data to. So that is definitely an outlier and something you should pay attention to. Kentucky, Nebraska, and New Hampshire, they kind of followed other, existing state privacy laws in their models. They didn't have necessarily anything that would stood out similar to Maryland, Minnesota, Rhode Island. However, there were 4 existing privacy laws: Colorado, California, Virginia, and even New Hampshire, which was a new law in 2024, passed an update this year. And those were mostly focused around expanding privacy protections to minors. So in California, for example, they now require affirmative authorization for the collection, use, and sharing of the personal information of minors under 18 years old. All right, so 2024, obviously it was a busy year in privacy, both in terms of the passing of new state privacy laws and amendments to existing legislation. To be honest, this movement shows no signs of slowing, and enforcement of these laws is even ramping up. We recently saw this by the Texas Attorney General's settlement with Meta for $1.4 billion after the company illegally collected and used biometric data from Texas residents without their consent, primarily related to their facial recognition feature on Facebook. So what should you do as a business, or what should your entity do as you move forward? It's really difficult, but you have to stay updated. Continuously monitor legal and regulatory developments and privacy laws. I know I get alerts on a daily basis. There is either an amendment that's going through, a new law being pushed forward, as well as, outside of the state comprehensive privacy laws, we know that there are various laws that are, focused on a single subject, like for in Illinois around biometric privacy. Several states have now health privacy laws as well, that go above and beyond maybe what HIPAA requires. So stay updated as best you can. There's a lot of resources out there, and it's good to be plugged in to ensure your company's keeping up. Review your data practices. So regularly assess and update data practices to ensure compliance with the latest state laws. Identify gaps. So conduct reviews and audits to identify and address any gaps in data protection measures you may have. And of course, be proactive. As I said, that's the only way we can move forward. There's so much, it's almost a constant influx of news, but you have to be proactive to stay up to date with all the different privacy amendments and new laws that are being pushed through on a daily basis. So, in conclusion, I think I've made clear today that the landscape of US state privacy legislation is rapidly evolving. Businesses must be proactive in adapting these changes to protect consumer privacy, as well as making sure you and your business can avoid any regulatory pitfalls or fines. With that, I want to turn it back over to Cliff and see if we have any questions in the chat.
Hi, David. Excellent presentation. Thank you for all this information. Um, yes, there are a couple of questions here I think that we could go through. Um, so the two that I think are the most relevant at the moment are the two that are open currently are so it said you mentioned that these laws apply to consumer provided data. What about data that's obtained through other sources? So, you know, metadata or location data or things like that.
Yeah, that's the interesting point. And I think that when you're reviewing these different laws and legislation, you have to be very, go through it with a fine-tooth comb in terms of what they're saying. Because you're exactly right. That type of information would not be included in terms of being able to amend the information or request deletion in some cases if it wasn't consumer provided. As we know, many businesses scrape data and get data from a lot of different places and build up a profile on individuals. So it really is unique in those laws that are specific to consumer provided. You should, make sure to pay attention to those explicitly because there are things that will not be included that you referenced.
Perfect. For large enterprise businesses that operate internationally and in all 50 states and clearly meet the revenue thresholds, how do you advise they approach this state by state landscape? Should they look at the most stringent laws and assume that if they can comply with those, they're good in other states? Or does this actually require somebody to go look at all 50 states' privacy laws and then try to form a matrix of compliance?
Yeah, so that's a great question. I can't advise a business on what to do, but what I can tell most businesses, what they used to do is like, hey, California is the most strict, right? If we're meeting California, we should be all right in the other 50 states.
Hmm.
What we're seeing now as more and more laws are passed, right, is that number one, there are, there's some uniqueness to each and every new one that we're seeing. Whereas, yes, you may be meeting most of the requirements if you're following California, but there might be one or two things that you also need to enforce that, as I kind of went through in the different examples during the presentation, that these laws, include something a little additional. Maybe they're not as stringent in this area, but they, require this notice here. So it's really difficult, I think, now to take like a one size fits all approach in terms of just saying, okay, we're abide by California, so we're good with everything. I think we really need to start looking at these on a case by case basis and, like I said, identify the gaps that may exist. I think previously we were really looking at, two models of state privacy laws for a long time as well, the California model, as well as the, never passed, but the Washington state privacy law model. A lot of states took that and were kind of running with it. So you kind of had these two models of what privacy laws look like. But things that are the Maryland data privacy bill this year, things are so quickly evolving and the consumer rights are starting to get so much stronger that, again, I think you need to really take a hard look and make sure you're identifying any gaps instead of taking a kind of one size fits all approach, in California per se, as I think a lot of businesses have been doing historically.
Sure. Thinking about frameworks and compliance, like I know that there are cybersecurity frameworks like this CSF and high trust, HIPAA that try to kind of cover just about everything. And some of the belief is that if you have a solid program, that you're going to be compliant anyway. Are there any data privacy frameworks that can be applied that would help you get close to all these states, or do you really truly have to just research every state?
Well, there's several frameworks. I mean, obviously, there's the data privacy framework, data protection framework that talks about sharing information, especially like when you're sharing information with, EU and making sure you're GDPR compliant. I think making sure you're GDPR, if you're an international company, as we were discussing, that's obviously a huge advantage in because you've had to be GDPR compliant. So a lot of these things at baseline you're already committed to across your business. Um, but it is a little more difficult. I think, if your baseline is, hey, I'm compliant with GDPR and the framework that privacy protections that go along with that, you're at a great starting point and baseline. But again, I think you still are going to have to search and make sure that none of these interesting gaps or additional protections show up and that you have a plan for how to address them.
Thank you. That's awesome. Okay, so we have a couple questions that kind of surround the GDPR and the EU.
Mhm.
Um, in your opinion, do you think the US will pass a national privacy law like GDPR? Um, will that be coming? I know it's kind of hard to predict.
Uh, you know, in my personal opinion, I don't feel super strongly that it will be. I just don't know. Obviously, we have a new administration. Um, there has not been a set out plan per se as being a priority for federal preemptive federal privacy legislation in the United States. I think the as I referenced, the federal legislation was making its way through this past year in 2024, was kind of in some ways shockingly close as we've gotten. It was a bipartisan bill, and really, I think, obviously would have made a lot of our jobs much easier in terms of being able to apply one standard across the board. But with that said, based on, my own personal view and not seeing it being a priority yet from anything I've seen from, plans for the administration, I don't see it as something that's happening anytime soon, but we can hope.
For sure. We'll keep hoping.
Yeah.
Um, okay, so two kind of questions that I'll sort of blend together. So, how would you approach GDPR compliance for a US based company that operates internationally? So, what would a company go look at first to begin to start to be compliant with GDPR? And then what are some challenges that businesses and governments face, in trying to clean up processes to be compliant in terms of database structures and operations?
Yeah, so there's a lot of great resources for GDPR because obviously international businesses that, when GDPR hit and people had to be compliant by a time frame, there are a lot of great resources that are out there. The ICO website is fantastic in breaking down all of the different requirements for GDPR. So that'd probably be my first stop. Um, but I think in terms of practicality, how do you really feel good? I think the first step you have to take is, I think it really comes down, and this will help you at the state level as well. And it's a really difficult exercise because you can never feel super confident about, do I know everything that's going on and all the data flows until you really do those data maps and you can understand what are the applications that exist in my business? What is the data flow? What is the information being collected and how can I ensure and understand all the different types of data so that I can be compliant with GDPR or whatever state privacy law. So I think data mapping is critical, obviously a requirement of GDPR as well. So if you're going to be compliant, you should have your data maps. But it's a crucial first step because when you rely on different business units within your organization, it's not nefarious, but not everyone thinks the same way as a privacy professional in terms of, oh, I didn't really consider that personal data. Is this personal data? If I would have known that, I would have come to you and done an assessment and blah blah blah. But doing those data maps and really getting entrenched in the technical data flows, I think is critical to being able to make sure that you understand everything that's going on in your business. And where the data is flowing from a domestic as well as international perspective, so you can come into compliance with GDPR.
Fantastic. Yeah, thank you so much. Somebody asked how you define data mapping. I think that's, identifying what data you have, where it is, and then classifying that data as PII or other types of data, right?
Right. It's really taking a look at really breaking down your processing activities, having a record of your data processing. That's another way of looking at it, right? Making sure you have a record of all the way your company processes data, right? And what applications and, what's your business unit? What applications do they have? What pieces of personal information are included in that application and how do they flow through the organization? I think is, they're a lot of work, but they are incredibly useful in making sure you're identifying gaps and being proactive.
Where could somebody go to find more resources on how to start to implement a data program, like using is there a NIST that you mentioned the NIST data privacy framework,
Yeah.
data protection
Um,
framework?
yeah, I can certainly pull some resources following this if that would be helpful to send out. I think there's a lot. Obviously, NIST provides a lot. Um, IEPP does a fantastic job of providing different frameworks for compliance as well in their resource page. So there's a lot out there to draw from, but I'm happy to provide some resources following this presentation.
Okay, awesome. And last question, then we'll end it because I know we're over time. Somebody asked about conflicting state requirements. So, is there ever a situation where complying with one state's requirements might make it impossible to comply with another state's requirements? Or does that not matter because the state requirement only applies to citizens
Yeah,
from that state, right?
right. I think, it generally, because, if you're dealing with something and you're looking at it, it should really only apply to that state. So they shouldn't, it makes it difficult to build the program and to apply across the board, like we said. But that's why it's kind of important to take that detailed view of like what are the unique, consumer rights, especially that are provided in this law versus another, so that if something happens, God forbid you have a breach or something occurs, you have a resource that you can go to and say like, this is what I have to do for those residents, in Utah, or this is what I have to do for California. So they shouldn't really. They may be different, but it makes our jobs a little bit more difficult. But they shouldn't be in conflict because it should be for the residents of the different states.
Awesome. All right. Thank you so very much for this conversation and this presentation. I think it's been very valuable. Our audience seems very engaged. So everyone, we will make this recording available, and any notes you send over, David will send that out along with a link to the recording. Thank you so much for joining us, and we
Yeah.
will wrap it up here. So thanks and have a great rest of your day.
Right. Thank you all very much. I appreciate it.
Thank you.